Supreme Court of Florida is now in session. Please be seated.
We now take up the fourth case on today's docket, Colley versus the State of Florida. Counsel?
Mr. Chief Justice, may it please the court. My name is George Burden. I'm here on behalf of Mr. James Colley Jr. Mr. Colley was sentenced to death for the murder of his wife, Amanda Colley, and her friend, Lindy Dobbins, in St. Augustine, Florida. We are here to contend that Judge Maltz was incorrect in instructing and finding two very weighty aggravating factors. Those aggravating factors were cold, calculated, premeditated, and heinous, atrocious, and cruel. And we think, in this particular case, requires a new sentencing hearing. And I say that because in the review of the trial, they conceded that Mr. Colley did this horrific murder. They said so in opening statement. They've never disputed that fact. What they dispute is the application of the aggravating factors. And now, you know, this is a post-Hearst environment where we require jury unanimity. And when a jury is not instructed properly, as you mentioned in Wood recently, there is a harmless error rule, but it's the harmless error rule that is a heightened kind of scrutiny in harmless error. And we would say that would be an automatic resentencing hearing if a jury is misinstructed. Now, I'd like to explain why CCP does not apply. You may recall in the facts of this case, and it's very unique, and let me digress a moment and say, there's not much about this case we don't know because of technology and experts and so forth, and the 911 calls. So we know what happened here. And you'd be hard-pressed to find a case with these kinds of facts. And the facts are, you had a marriage that was estranged. Mr. Colley had an injunction for going to the house, but the evidence showed he routinely went to the house anyway because they were still not in a divorce posture and there were the children involved. And in this particular case, Mrs. Colley informed the husband that she wasn't feeling well and to take the kids. After a night of drinking and doing drugs, he went to the house at approximately 4 o'clock in the morning and she was not there. But what did he find in the house? He found evidence that she was having a relationship with another man. Went to a neighbor right thereafter and he was extremely upset, and he disclosed what was found later. He trashed the house. Here's a man who's a financial sector professional in a middle-class neighborhood that went back in and trashed his own house when he has an injunction not to be there. That's how emotionally upset he was. And
well, you know, in any of these cases involving a domestic murder, people are upset, okay? That's kind of intrinsic to it. But it seems like to me that, I mean, you're focusing on these things that happened earlier, but what about the circumstances that lead up from the time he was in court that morning, right? It's seemingly behaving in a very rational manner, understanding things, asking intelligent questions, behaving himself very well, right?
Absolutely.
Okay, so he does that, and then he's off to commit these murders. Isn't that correct? And there's a secret, but we can know that he is off to do that, and that this is something that's set in motion. It's not like he got there to confront her and then it got out of control and he killed her. No.
No, sir.
It's not like that. I mean, we can see that, I mean, the jury can see these indicia that he's going there with a plan to do damage, to commit acts of extreme violence. Isn't that correct?
That is correct, Justice Kennedy. And I will say to you, and you'll see it throughout your career sitting up there, People are on their best behavior in front of a judge. They really are. And that's what this gentleman was. He was before a judge, and he was on his best behavior.
Well, that is generally true, but not universally true.
That is correct. That is correct. But let me give you a fact that changes the way you are viewing this, your perspective entirely. Just before he went to court, he had a short conversation with his wife. And in that call, he was apologizing for what he did and that he would come and pay and make it right. And so this in effect was the beginning of a cooling off period. Because remember, if you listen to the opening statement of the prosecutor in this case, Ms. Dutton, she makes it clear that from the time he discovered those items in the house that set him off till the time the murder occurred, there was no time where he had a time to cool off and sleep it off or have it. It was a continuous period of time from 4:30 in the morning to 10:30 in the morning when the shooting occurred.
Well, how does the call to the wife about going to make it right and pay for it, how does that undermine the perspective I was explaining?
It supports your perspective. It absolutely supports your perspective. There was this beginning that maybe things will be okay. And he went to court, and after court, he didn't go to the house. That's the key. He didn't, because he was going to make things right and things were going to be okay. But they had a 14-minute phone conversation. And in that 14-minute phone conversation, what happened? We know very little, but what we can call from his talk with the experts, the mental experts, because remember, he had this claim of parasomnia, and his memory was spotty, but what he did say was that he told the police, and they are coming. And she had promised him that she would not do anything about that, and she held that promise. If you recall on the record, the police did come, and she said, I am not making a claim here of a violation. I want to talk to my lawyer, just like she promised him. But that set him off. That re-enraged him.
Well, how long was that before the murders took place?
Less than 30 minutes. Less than 30 minutes. From a guy who was so emotionally distraught at the beginning of this episode that he trashed his own house with an injunction. And it never stopped. It started to call from being in front of a judge and having this talk about I'll pay you and make this right. That supports your perspective entirely.
Let me ask you just basically, what's our standard of review on the issue that you're arguing now?
It's whether or not there is substantial competent evidence to support.
Okay. Because it reads like and sounds like you're asking us to reweigh the evidence by arguing evidence that could cause the finder of fact to come to a different conclusion than they did. And you know, the state points out the evidence that would support a finding of CCP, and I don't see anything or haven't heard anything that would indicate why that would not be the kind of things that Justice CANADY brought out, but other facts wouldn't be sufficient evidence to be competent substantial evidence to support the finding.
Justice Lawson, I'm not supporting a reweighing of the evidence at all. Let's be clear here. The evidence supports exactly what I'm saying, and the judge, in the way Judge Maltz, in his lengthy order, characterized the events, was consistent with the state's theme, where suddenly the emotion got shut off, just like a switch. It got shut off, and then he went into this calculated plan. Sure, we've seen that in this is a love triangle domestic case. Let's be clear. And when we've had those cases where CCP has been upheld, like for example, Cop Show, perfect example. He had 3 days to cool off, and he planned the murder of his wife. Far different. Allred, which is a case that's very close to this. He spent weeks on target practice of the third person in the triangle and threatened to kill him repeatedly. None of that happened here. In fact, when he showed up at the house, there was no clue that he was going to murder anybody in the minds of the people in the house based on past conduct.
Until they started shooting through the sliding glass doors, then they probably got an idea.
Yes, sir. Mr. Dubley, a former Marine, definitely got it. Absolutely. But in all those other cases, Well, and Santos, you have to overrule Santos to uphold CCP here. Because in the Santos case, which is identical here, although it's a little different perspective. In Santos, the mother of his child would not give his name, and it aggravated him. And 2 days or 3 days before the murder, he threatened to kill her, and she called the police. And they didn't find a gun on him. They released him. Again, here, these threats of murder. We never had that in this case. There was no threat of murder, ever. He showed up from the event that got him enraged and went to that house within 7 hours.
So is what you're saying then that anyone who is that emotionally strained cannot develop the heightened premeditation required?
Absolutely, Justice LeBarge. In fact, you've said so in Santos, specifically said it in Santos.
Well, I mean, there's one thing where a person views a particular event that enrages him or her and acts in a sudden fashion. It's another thing to get really upset an hour earlier and still be upset an hour later. I mean, why can't you develop this heightened premeditation during that time? Just because you're upset doesn't stop you from thinking.
Well, I was referring to it in the context of cold, with a careful plan. There was no careful plan here. I mean, as soon as he heard that that man was at his house, he went there as fast as he could to kill him. Period.
I mean, the perfect example of the heightened premeditation would be like an assassin sitting in the top of a roof like Lee Harvey Oswald, waiting for the president to drive by and coolly shoot him. We don't get that here. We usually get situations such as this.
Well, that's been the expansion of CCP since it was developed. When it was first thought of, and we're one of the few states that has it in the country, is execution, where you plan that I'm going to wake up today and kill somebody. That was the initial way this court interpreted CCP. It has been expanded to boozia, where somebody who is a soulless killing machine in a drug binge and is there and harms somebody, and then the other person comes home, and the viciousness and the way he still stayed there and didn't run out of the house in this drug binge, well, that was enough for CCP. There's been a great expansion by this court in what CCP was originally contemplated to be. And if you find it here, it becomes an automatic aggravator, because you don't have the coldness in this case, clearly. You don't have a day to reflect on the emotional turmoil that he discovered that his wife had a lover, and discovered then, and this is to Justice Kennedy's perspective, that he was coming to grips with that, and he was heading to work after court. He was heading to work. They have the cell phone, where he was going. They know all the facts of this case. He was heading to work. And then on the phone call, well, the police are coming, he called them. And boom, that's what was reignited, that emotional hardship, that you don't have the coldness necessary. And you don't have the heightened premeditation either. I honestly think, and this court doesn't accept this, but if the person didn't wake up that day deciding to kill somebody, you can't have CCP. If it's formed during the course of a day, you shouldn't be able to. If you really, truly want to narrow the class of people eligible for the death penalty in a state, you wouldn't. But
so is it your argument that the instruction that's given doesn't sufficiently narrow the class? Because you're not arguing that the jury was improperly instructed as to what they had to find beyond a reasonable doubt in order to find this aggravator, correct?
Correct.
Okay.
It does narrow. In fact, right here today narrows the class, because you're listening to a direct appeal and whether they're properly done. Judge Maltz is narrowing when he does his job. These are all narrowing in a broader context where we've gone from 8 to 16 aggravators, and the way that you look at them has been expanded. But since you still have these other safeguards, it still passes Eighth Amendment muster. But I will tell this court, because I argued for 13 years.
Are there cases specifically that you think were incorrectly decided and incorrectly expanded the evidence necessary to establish?
Buzio is one of them. It comes right to mind. That wasn't a CCP case in my mind. When someone is in a drug binge, and when we had the cocaine epidemic, these people are not, because once he did the crime, what did he do? He went to the bank with their stuff to a teller and got arrested right on the spot. Who in their right mind does that? That there's this careful plan. That's what happened in Buzia. But this court was perfectly content to say that is CCP. And I'll say that, to finish that point, this court has been put on notice from 2014 by the U.S. Supreme Court that they're looking at this now in Eighth Amendment analysis as to whether or not you're going back to the days pre-Furman, where there are so many aggravators. The way that you do this process is so skewed that the ability to have discrimination, arbitrariness is going to be back. And for 13 years, I came up here telling this court that the Sixth Amendment was being violated because you weren't letting the jury find aggravators. And now you're going to be hearing this until the U.S. Supreme Court comes back on the Eighth Amendment and saying you're not doing your job with these aggravators as well. If there's any more questions about CCP, I'd like to move on to heinous, atrocious, and cruel.
Let me just ask you one thing. You, in your brief, talk about the United States Supreme Court case of Brown, and seem to suggest, if I'm understanding your brief correctly, that that the way that we deal with harmless error in this context is inconsistent with the Eighth Amendment. Is that your argument?
I'm saying it could be. The Wood case, which I didn't see, and I apologize to this court, you decided Wood recently, and in the language in Wood, you talked about harmless error analysis in that context, and your perspective that you gave to the state was that you were going to really enforce the Julio in the way that it means, and it's going to be tough once this kind of error happens, that you're going to not give relief. So that was reassuring to the state that you would do that proper exercise.
So the way I believe that we've handled harmless error in this context before is to say, okay, assuming that this aggravator, the evidence wasn't sufficient or it shouldn't have been presented, then we're going to essentially reweigh and determine whether without that aggravator, it's clear beyond a reasonable doubt that the jury still would have found that the aggravators outweigh the mitigators. I mean, that's what we've done. There's language in Brown that suggests that the Supreme Court's left it up to the states to do that kind of analysis. Would you agree?
They do, but the difference here now is jury unanimity changes everything, Justice Lawson. It changes everything. It just takes one vote, and then it's life. So how could you sit there in this court and make a judgment as to whether or not a juror wasn't properly swayed one way or another on two very weighty aggravators, CCP and Hack? You can't. And just like you did after Hearst, if there was not a unanimous death recommendation, you just order a new sentencing hearing.
So the standard that's set forth at the end of Brown, something like this, that the error would be harmful any time that the jury would not have gotten the same evidence if that aggravator had not been presented, correct?
No, Justice Lawson. The evidence isn't the issue. The evidence, because most of the evidence...
That's the language that you quote from Brown in your brief.
Right, but what I'm not speaking to the evidence before the jury in this case. I'm talking about the fact that the judge is telling them they can consider that evidence for this aggravation. That's the issue. And because the evidence is always there most of the time in a trial. They don't have a special evidentiary hearing later. Most of the time it's from the trial itself, from relevant evidence. It's the fact that they're told this evidence can support this. And then you're saying, well, the jury's saying, well, instead of 3 aggravators, this is 5. This must be the most aggravated case then. If they're not if they're not instructed on CCP, they're not instructed on Hack, it's a different jury posture. And you would all agree with that. And so when they're improperly instructed, then you can't sit and say, well, they would have found a 12-0 vote anyway without this, is our position. Now, in heinous, atrocious, and cruel, this is a case, too, where we know exactly what happened. We have the 911 call. We have the phone records of Mr. Colley before he got there and after he got there. So we know the time that occurred. Now, there was only one time that this court has held that a crime is heinous, atrocious, and cruel where the testimony would say that the time that it took for someone to be harmed and in fear and die is less than a minute. And that was a case involving stabbing. That was the Rollins case that you held that. But this is not a stabbing case. This is a shooting case. And in this case,
well, in the case of the wife, it's multiple shootings, or at least there's a view of the evidence that the trial judge took, that it's multiple shots fired with a separation between the first and then the final. And with respect to the wife also, isn't it true that there's testimony that supports that there were effectively defensive wounds on her arms that she was put up trying to protect herself from these shots? Isn't that correct?
That is correct. The medical examiner, Dr. Bulick, said that there were defensive wound shots because of the way she lifted her legs, because the shot that was immediately fatal, she would not have been able to lift her legs. So we know that there were defensive shots before the fatal shot. But Dr. Bulick made it very clear he could not say with scientific certainty what shot sequence there was. But let me tell you what he said that was critically important when it comes to Hack. Because Hack was proven, really, the judge accepted Rachel Hendricks' testimony on its face. And we know her testimony wasn't correct in many aspects because we have independent scientific evidence to show it wasn't. I'll give you an example. She said when she arrived, the deputy sheriff that had come there being called by the boyfriend was just leaving. Well, we know that's not true because there was a surveillance camera that showed when she arrived and that car had left 15 minutes before. So we know that her testimony you can't take on face value just from the start. Let me give you another example. She made a 911 call right after the event, and wouldn't you all agree? A 911 call right after it happened was probably the best evidence of what occurred at that time and not testimony at trial years later. I think anybody would accept that. Well, what did she say in the 911 call? She said things that were different, but one thing she made clear. They asked her to give a description of Mr. Colley. And what did she say? He had a white shirt and black pants. And he was covered in blood. Now that is critical, and I'll explain why. If you accept the sentencing order of Judge Maltz and how things happened in relating to Hack, you would have to say that the first shot occurred to Mrs. Colley, and then he went into the closet and murdered Mrs. Dobbins. That's what you'd have to accept. But if you remember, Miss Hendricks was behind the door of the closet and got pushed behind that door. And she said before the first shot was fired, she fled. Now, how could she have seen blood on his shirt? Because if you look at Dr. Bulick's testimony, and it's right at the very beginning of his testimony, he says that the shots to the wife were, none of them were up close. They were between 4 and 34 feet away. There could not, if a first shot was that shot, where'd the blood come from? Didn't come from the wife. She was too far away, according to the doctor's testimony. Where it came from Miss Dobbins because she was the first person shot. Because what happened really was Miss Hendricks was behind the door and the other person was executed, and the blood, because it was immediate, he was right up to the temple and shot her right in the temple, point blank range. And that's how the blood got on him, and that's why she said she saw it. But if you accept the testimony the judge accepted, She didn't see anybody get shot, yet she knew that Mrs. Colley was shot at point blank range in the closet behind the door. That's what she testified to at trial. But at the 911 call, we know what happened. And you can hear it on the 911 call that someone screamed after the shooting. It was her leaving from behind the door after she left, murdering Miss Dobbins. That's how it occurred. But you see, her testimony, you know, it's tough. It's tough for this court to second guess that.
Counsel, you are now in your rebuttal time. You can keep going, but you are consuming rebuttal time.
I just want to make one more point about Hack then. You'd have to overrule Cheshire as well if you find Hack in this case, because this is a heat of passion case. Even though there is testimony, and your perspective, Justice Kennedy, was right on target. If you look at the sentencing order at face value, you could say that there was seconds of knowledge of death, which are far different than any other case you've seen before, because they never knew she was coming, like Allred, never knew they were coming, and she was in the bathroom for over a minute and a half before he even, in Allred, where she broke in, where you upheld that.
I mean, the idea that we would not look at this whole context where from the time he shoots out the window, out the sliding glass doors, and the horror that this would have to create. I mean, how long did that take?
Less than 3 minutes.
Okay. But that, wouldn't you agree that that would be part of this whole scenario of looking at what the perception of the victims is?
It would if they had any knowledge beforehand that he was coming and he intended to kill someone. And that's all the other cases have that feature. Like Santos. You didn't find Hack in Santos. And he threatened her life. And then you saw her, she went running and screaming. Chased her down and he killed her. And you didn't find Hack in that case.
Well, I wasn't here for Santos.
I understand, sir.
That case, we've said things about that case subsequently, haven't we?
Well, in Lynch, you said that, not in terms of Hack, but in CCP, you said in Lynch that there is no exception for a domestic violence, but you didn't say so in terms that would overrule Santos in any way. You just said Lynch was a attempted murder-suicide. It wasn't a domestic case to begin with. That's what you said, Lynch. And in Allred, you mentioned Lynch and saying we don't look at it the same way, but you didn't overrule it. It certainly can negate cold, like we've argued today. You haven't said it can't, so it must, and I'll reserve the remainder of my time. Thank you.
Good morning, may it please the court. I'm Patrick BOBEK with the Attorney General's Office, and I represent the state of Florida in this case. So first, I'd like to talk about the CCP aggravator and how it applies to both victims. When you look at the evidence in this case and the evidence that the judge relied on in his sentencing order, you see that this isn't a man who was overburdened by his emotional frenzy. He didn't drive straight from, he was driving to work, and he had that phone call with his wife. If he was so enraged he wanted to kill them immediately, he would have driven straight to her house. And that's not what he did. That's where the CCP comes into play, because we see his planning. He arms himself beforehand. He doesn't go to his wife's house. He goes to the house he's staying at, his sister's house. There he grabs multiple guns and a bunch of ammunition. Then again, he doesn't go to his wife's house. He goes to a gas station outside her neighborhood, and he buys $3 worth of gas to top off his gas tank. And that's so he can drive farther, longer, after committing the crime. Then again, he doesn't go to his wife's house. He parks in an adjacent neighborhood in a foreclosed home where no one will wonder why he's parking in this driveway. And again, he doesn't go straight to his wife's house. He sneaks up behind the house. That's when he starts shooting into the house from the outside, yelling, "Where is he?" And at every step, he could have stopped what he was doing and gone home or gone to work. He had nearly an hour between the phone call with his wife and getting to the house, where he was alone with his thoughts in his car, thinking about what he was doing. And every step of the way, he could have turned back. Instead, he didn't. And then he went into the house, and he hunted down these women, and he killed them. That is CCP. You don't have to wake up that morning thinking, I'm going to kill somebody. This court does not put any sort of time limit on how CCP can develop. Merely that you have the time to have your cold reflection, which he did. He was alone in his car. He was making phone calls and texting. but he knew what he was going to do. He sent what was considered possibly a goodbye text to his girlfriend at the time, saying, "I love you," when he was right outside the house. This was a man who had a plan. From the moment he knew that Lamar Duberly, who was the focus of his jealous obsession, was at his house with his wife, he wanted to kill him and his wife, and apparently anybody else he found in the house. And that's why CCP applies here. As to HAC, it's correct that in most shooting cases, this court says that HAC can't apply because of the instantaneous nature of the wounds and death. But that's not true if there are other circumstances surrounding the killings that show that there was fear and knowledge of imminent death in the victims. And the focus in HAC is not the defendant's actions, but what the victims could have reasonably known what was about to happen. And this court has previously said that the fear of imminent death need only last seconds. And so while I agree that there was a short period of time when they knew they were going to die, both victims were well aware that their lives were ending that day. And you can tell that in the 911 calls, which, by the way, back up the court's findings about how exactly the murders played out. I highly encourage this court to listen to the 911 calls if you have them. In Amanda Colley's call, you can hear her yelling and screaming at the defendant to put the gun down. You hear a gunshot. She stops screaming for a little bit. You hear a couple more gunshots about 10 to 15 seconds later. And that's when he's killing Lindy. And then he comes back out. She's begging for her life. He calls her a whore and shoots her. He runs out of bullets in one gun, drops it, pulls out the other, and shoots her until she dies. She knew she was dying. Her terror was evident on this 911 call.
Let me ask you this. With respect to the HAC aggravator, if
Yes.
I understand opposing counsel's argument correctly, it seems to be that the trial judge should not have been able to rely on Rachel Hendricks' testimony as to the timing of the shots and the course of the killing, that apparently isn't competent substantial evidence that the trial judge could rely on in making the HAC finding. Can you address that?
Yeah, I would disagree with that because it does match Amanda Colley's 911 call. Her description of the events matches the gunshots we hear on the call. And Amanda is still alive, yelling and begging for her life after we hear the gunshots that are slightly farther away. So maybe she said things slightly differently in her 911 call. She was in shock. She had a lot more time to think about what actually occurred to her that morning. So I think the judge is perfectly able to make that credibility distinction, especially when he compares it to other evidence in the case. I don't think her testimony was so contradictory and unreliable that he couldn't have used it in his sentencing order. And for HAC for Lindy Dobbins, if we use the 911 call and Lindy's 911 call and Amanda's, you can hear Lindy say, "I've been shot." And then what can only be described as, abject terror screaming before she's murdered. Using the 911 calls and Rachel's testimony, we can put ourselves in Lindy's head. She hears her friend yelling at her husband, and then she hears a gunshot and silence. At this point, she must assume her friend has been murdered.
Was the voice identified at trial, the female voice that said, "Oh my goodness, I've been shot"?
So the 911 calls, when they're entered, Rachel testified that she heard their voices on the 911 calls, but she didn't identify this as Amanda's and this is Lindy's. But when you listen to the 911 calls, the longer one where you can hear Amanda, it's reasonable for the judge to have found that that was her phone call because it caught her voice, whereas the other phone call didn't catch her voice as much. So in Lindy's phone call, you can hear her say, "I've been shot." She knows that her friend's been murdered, and then the man starts trying to force his way into the closet, and then he shoots her. At this point, maybe she would have thought she could get away before he starts forcing his way into the closet. But now she's trapped in the back of a closet with an enraged man who's armed with a gun, and has nowhere to go.
Is there any explanation as to why Miss Dobbins was killed but not Miss Hendricks?
Rachel Hendricks testified that when he busted down the door, it went between her and him, and he was walking with his gun out straight forward to Lindy, so he didn't immediately see her because the door was in the way. So that was her opportunity to get away. And that's, the only explanation, the only reason we can see why she was able to get away.
Was there anything in the record to indicate that he would have an intent to kill Ms. Dobbins for any reason other than the fact that she happened to be there?
Yes, there were text messages he sent to his neighbor, and he partially blamed Lindy for the marriage falling apart. He sent things like, Lindy came over and now Amanda says she doesn't love me. He called Lindy names. So he blamed her. He didn't know she was at the house when he was on his way there, but I think when he saw her, he took the opportunity. And so, Lindy, while she was only aware of her death for a short period of time, if you listen to her 911 call, it is very clear that she was aware. I would point this court to the Allred case. While there was more warning for the victim in that case that Allred wanted to kill her, this court spent a lot of time talking about the phone call, the 1 minute and 17-second phone call where you can hear her imminent knowledge of her death. And that's another case I've handled, so I've heard the 911 calls in both cases, and I think you'll find that they hit you in the same way, that these victims knew what was coming. And that's why HAC applies to both of the victims. As opposed, when we come to the issue of instructing the jury on these aggravators, first of all, the state's position is that the aggravators were properly found by the jury and the judge, so there can't be error when they were properly found. But if this court decides that one or both should be struck, then you would do as Justice Lawson suggested. You would then reweigh the aggravators versus the mitigators. And this is a case where the mitigation was pretty much non-existent. I think it was best summarized by a statement from one of the defendant's friends, John Schwinghammer, when he said, the defendant was just a normal, typical good guy. That was what the mitigation presentation was in this case. He was a good dad, he was a good employee, he was a good uncle, a good neighbor, a good coach, with little criminal history outside the DV injunction. So that is not very persuasive mitigation. The mitigation this court has looked to in the past as persuasive are, severe mental health issues, brain damage, terrible abusive upbringing, and from all accounts, he had a normal childhood and a very tight-knit family. So the mitigation in this case is some of the lowest this court is likely to see, and the aggravation is some of the highest. So even if you struck one or both aggravators, you would still find the weighing process to fall on death. If there are no other questions, I just ask that this court uphold the convictions and sentences. Thanks.
Mr. Chief Justice, briefly, Justice Lawson brought out a great question. Were the different voices identified in this trial? They were not at all, in fact. Ms. Hendricks' testimony was she saw Lindy Dobbins dial 911 and it was open and she never spoke into the phone. And the 911 calls, you never hear when the operator's 911, what's your emergency? You never hear either person answer that question, the wife or Miss Dobbins. And Miss Dobbins was found dead in the closet with the phone to her ear. But you had two phones, 911 going at the same time. So you had a perspective of two different phones no more than 15 feet away or even less. So
but we know what was coming from the particular individual phones.
Yes. But we don't know, and so...
And where did the "oh my goodness, I've been shot" come from?
That was...
Whose phone?
We don't know, because they didn't identify whose phone was who. We don't know.
I mean, you could clearly hear the former wife's voice on one of the calls.
Absolutely.
And then there was another call. So was the "oh my goodness, I've been shot" on...
Yes, and in fact, Ms. Hendricks testifies that Ms. Dobbins never said such a thing. I've been shot. She does say that she says things, but we've never heard the things that Ms. Hendricks said she said. If you look at the record, Ms. Hendricks testifies that Lindy said things, But if the phone is right to her mouth, you'd suspect you would have heard them. But you didn't. And this is the problem with her testimony. There's a lot of gaps that don't tie up with the other evidence. There's no evidence that Ms. Dobbins ever said anything on the phone calls themselves. It was all the wife, is our position. And we wish that the state identified whose phone was who and who called first, because they weren't called at the same time. One call happened before the shooting. We say that must have been Ms. Dobbins because we have the testimony Ms. Hendricks said she dialed and was there so she could catch what was going on, you see. And as far as a hack from Ms. Dobbins, remember that we talked about him shooting through the door, but from the time he got in the house and the time that she died instantly was...
Counsel, you've used all your time. I'll give you another 30 seconds to sum
was
it
a
up.
matter of seconds. Was simply a matter of seconds. If you find hack on Lindy Dobbins, every murder is hack in the state of Florida. Every single one. You cannot say that the evidence supported heinous, atrocious, and cruel in the tragic death of Lindy Dobbins. Thank you very much.
We thank you both for your arguments. We'll now move to the final case on today's docket, Smith versus the state of Florida.